Welcome to the video. First, we will introduce the core problem. What happens after an F-1 student status violation or practical overstay, and whether a ban applies or you're simply inadmissible. Next, we will outline how unlawful presence is calculated, why F-1 duration of status is unique, and how consular discretion under Section 214B often becomes the main obstacle, even when a formal bar does not apply. Then, we will walk through practical steps, common scenarios, and strategies to prepare. Finally, stay until the end for key takeaways and a call to action. To set the stage, here is our agenda. First, we will clarify the core concepts and myths. Next, we will decode duration of status and how it interacts with unlawful presence. Then, we will compare automatic bars to consular discretion under 214B. After that, we will look at realistic outcomes and timelines. Subsequently, we will present an action plan and documentation checklist. We will also include short quizzes to reinforce your understanding. Finally, we will conclude with key takeaways and resources. Before we proceed, an important disclaimer. This content is for general educational purposes and does not constitute legal advice, because immigration outcomes turn on specific facts and records, including your I-94, I-20 history, CVIS notes, and any USCIS or court communications. You should consult a qualified U.S. immigration attorney for advice tailored to your situation. With that said, let's transition into the core concepts. To begin, let's establish the big picture. For many F-1 students, the I-94 shows duration of status, or D/S, instead of a fixed expiration date. With D/S, unlawful presence usually does not begin merely because your I-20 ended, or you stopped attending classes. Instead, unlawful presence typically starts when a recognized authority, USCIS, or an immigration judge, formally determines that you violated status. Consequently, a practical overstay may yield 0 days of unlawful presence. Next, remember that if you do accrue unlawful presence and depart, 180 to 364 days triggers a 3-year bar, and 365 or more days triggers a 10-year bar. However, even in scenarios without a formal bar, consular officers apply Section 214B, which presumes immigrant intent. Prior non-compliance significantly damages credibility, making a refusal likely if you cannot demonstrate strong non-immigrant ties. Now let's drill down into D/S mechanics. Let's examine duration of status more closely. D/S ties your lawful stay to ongoing compliance with student rules, full-time study, maintaining SEVI-S status, and following authorized training like OPT. If there is no formal determination of a status violation by USCIS or an immigration judge, unlawful presence typically does not accrue automatically for D/S holders. Therefore, a so-called 178-day practical overstay may translate to 0 days of unlawful presence, depending on the record. Nevertheless, this does not erase the credibility concerns. Consular officers may view any period of non-compliance as a serious negative factor. Additionally, how and when you departed, plus the precise documentation in your file, may influence how your situation is assessed. Moving forward, let's compare automatic bars with discretionary refusals. Here's a side-by-side comparison. On the left, automatic bars arise from statutory unlawful presence accrued before departure. 180 to 364 days leads to a 3-year bar. 365 or more days leads to a 10-year bar. These are statutory consequences. On the right, Section 214B gives consular officers broad discretion to refuse non-immigrant visas if you cannot overcome the presumption of immigrant intent. Prior non-compliance or weak ties abroad can drive a refusal, even when unlawful presence days are 0. In short, even absent a formal ban, you may still face refusal based on credibility and ties. Next, let's visualize timelines and decision points. This timeline illustrates the sequence of events from the end of the I-20 through a practical overstay and into the next visa application. First, identify whether there was any formal finding by USCIS or an immigration judge, because that determines when lawful presence ended and if unlawful presence accrued. Next, note the departure date, since bars attach upon leaving the United States after accruing unlawful presence. Then, plan for a consultation with an immigration attorney to audit your I-94, I-20, SEVIS, and any USCIS correspondence. Finally, before applying again, prepare substantial evidence of non-immigrant intent to address likely 214B scrutiny. Now let's add structure with a flowchart dedicated to D/S unlawful presence triggers. This flowchart clarifies the D/S specific trigger for unlawful presence. We start with an F-1 holder admitted for duration of status. The decision diamond asks whether there has been a formal status violation finding by USCIS or an immigration judge. If the answer is yes, unlawful presence begins the day after that finding. From there, we branch based on the total days accrued. Under 180 days yields no automatic bar. 180 to 364 days creates a 3-year bar, and 365 or more creates a 10-year bar. If the answer is no, unlawful presence may remain 0, even after a practical overstay. Nevertheless, a note emphasizes that 214B refusals remain a significant risk due to credibility concerns. With that foundation, let's quantify scenarios in a simple table. This table lists representative scenarios. First, a DS holder with a 178-day practical overstay but no formal finding may have 0 days of unlawful presence. Thus, no automatic ban, yet a high 214B risk due to noncompliance. Next, if there is a USCIS finding followed by 220 days before departure, a 3-year bar applies. Similarly, 370 days after such a finding leads to a 10-year bar. For fixed-date I-94 holders, a 170-day overstay does not trigger an automatic bar, but 185 days would trigger a 3-year bar upon departure. In all cases, 214B risk remains high because prior noncompliance undermines credibility. Now let's test your understanding with a short quiz. Quiz time. Question. For an F-1 student admitted with D/S who practically overstayed 178 days but has no USCIS or judge finding, how many days of statutory unlawful presence likely accrued? Options are A. 0 days, B. 90 days, C. 178 days, D. It always starts when the I-20 ends. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. 0 days. For D/S entries, unlawful presence typically begins only after a formal status violation finding by USCIS or an immigration judge. Without that, a practical overstay may not convert into statutory unlawful presence. Next, let's outline an action plan to prepare for any future application. Here is a practical action plan. First, collect your records. I-94, all I-20s, CVIS history, any USCIS correspondence, and proof of departure. Second, consult a qualified immigration attorney to assess whether unlawful presence accrued and to interpret your records correctly. Third, distinguish between practical overstay and statutory unlawful presence. Fourth, assemble strong evidence of non-immigrant intent ties to your home country, stable employment, property, close family obligations, and consistent travel history. Fifth, prepare a concise narrative that honestly acknowledges past non-compliance and explains how circumstances have changed. Sixth, consider timing in the most suitable visa category. Finally, anticipate rigorous 214B questioning and practice delivering clear, credible answers. Next, let's provide a Markdown-style checklist of documents and talking points. This section presents a Markdown-style checklist. First, assemble your I-94, all I-20 forms, SCVIS updates, any USCIS notices about findings, and proof of departure. Next, gather evidence of ties abroad, such as employment letters, property documents, financial statements, and family obligations. Then, prepare concise talking points, acknowledge the status issue, explain what has changed, emphasize your time-bound plans, and ensure your answers match your documents and the DS-160. Now, to reinforce the concepts, let's create a mind map of the decision landscape. This mind map centers on the F-1 Overstay aftermath. One branch addresses unlawful presence, noting that D/S typically requires a formal finding before days accrue, and outlining thresholds that trigger 3- and 10-year bars. Another branch emphasizes 214B, discretion, where credibility damage and weak ties can lead to refusals even when unlawful presence is 0. A third branch provides an action plan: records audit, attorney consultation, evidence of ties, a candid narrative, and strategic timing. A final branch outlines possible outcomes, ranging from no formal ban but a likely refusal, to a bar attaching upon departure, to later reapplication with a stronger case. Next, let's take a second quiz to check comprehension. Second quiz question: which statement best explains why a B1/B2 visa might still be refused after a D/S overstay with 0 days of unlawful presence? Options are A, because the 3-year bar always applies; B, because Section 214, B presumes immigrant intent and prior non-compliance undermines credibility; C, because DS automatically converts to a fixed-date visa; and D, because USCIS controls consular decisions. Notion: you may pause the video now to consider your answer. We will discuss the answer in the next section. The correct answer is B. Under Section 214B, consular officers must presume immigrant intent. Prior non-compliance weakens credibility, so even with 0 days of unlawful presence, an officer can refuse a B1/B2 visa if you cannot demonstrate strong ties and a credible plan to return. Now let's highlight the key points you should remember. These are the key points. Duration of status usually requires a formal finding for unlawful presence to accrue. Short practical overstays may avoid automatic bans, but they do not erase credibility issues. Section 214B. Refusals can happen even with 0 days of unlawful presence. To clarify your status reliably, consult an immigration attorney, or pursue an actual consular decision. Finally, overcoming the presumption of immigrant intent requires strong documentation and a coherent, honest narrative. Next, we will summarize and wrap up. In summary, for F-1 students admitted with D/S, unlawful presence usually begins after a formal finding rather than automatically at the I-20 end date. Therefore, a 178-day practical overstay may equal 0 days of unlawful presence. Nevertheless, Section 214B remains a substantial obstacle due to presumed immigrant intent and the credibility damage from prior non-compliance. For precise guidance, consult a qualified immigration attorney and assemble a robust set of evidence before applying. Be honest, concise, and consistent across all forms and interviews. Finally, let's close with our thank you message and a call to action. Thank you for watching. If you found this useful, please like, share, and subscribe. Share your questions or scenarios in the comments so we can address them in future videos. Your engagement helps others find accurate information. See you next time.